On the other hand, no case is filed on bigger companies because they can afford to appoint a lawyer, appoint a representative, have a license with the registrar's office. A person who is having a company with rupees 5 lakhs or rupees 2 lakhs or rupees 10 lakhs of capital. A small factory or business does not have that much of resources to go and have a license with the registrar of companies. The result is that cases are filed against him, and where a fine of rupees 50 could have been sufficient for settlement, a fine of rupees 5,000 is imposed. The same law is not applied to the public companies and government corporations. Once I was chairman of the Bihar Industrial Development Corporation. In that corporation, for the last 5 years, the balance sheet was not audited. I inquired why the registrar did not file a case against them. They said that it is headed by a managing director who is an IAS officer and no case can be filed against an IAS officer. He is big bureaucrat. He is much higher than the registrar of companies. That is why I suggest 2 or 3 things. Small people are actually being tortured and bigger ones go scot free. This is practically happening. So, for better growth of the companies, my suggestions are 3 in number. First, simplify the forms. Make a division of companies with a capital of rupees 20 lakhs and below and the companies with the paid up capital of rupees 20 lakhs and above. In the case of companies below rupees 20 lakhs, share capital burden and difficulties should be lesser. The forms should be simpler. In case of failure to submit forms or delay in the submission of their reports, there should be a fine only, say of rupees 50 or rupees 500, but no prosecution. For bigger companies, you have whatever laws you have got today. Make another category of the public undertakings. The government companies. Such companies should be treated on a different footing because 100% shares invested belong to the government. It is the people's money. It is managed officially. There is no personal interest involved. The delay is because of some administrative difficulties. So, keep such companies in a different category. Fourthly, in case you are not able to amend this, the only alternative is don't allow small companies to grow. Don't allow them any registration. If you allow them registration, you force them to follow these rules, and if they fail, you take them to the court of harassment. Mr. Vice Chairman, Sir, I am very thankful to you and the honorable members who have participated in the discussion. I have heard with great attention the various speeches made by the honorable members in the foregoing debate on this bill. Before reacting to the individual points made by the honorable members, I would like to say that the present amendment bill cannot be deemed to be a recodification of the entire Companies Act. This bill incorporates provisions of an urgent nature which have to be brought not only for the effective regulation of the corporate sector but also for its smooth functioning. The corporate sector encompasses various sections of the people and not only companies and their management. We have to protect the interest of the shareholders, the depositors, employees, public interest, while also looking at the interest of the companies and their management. If we go carefully through the various provisions embodied in the bill, you will find that the different provisions have taken care of the interest of different sections of the people. While on the one hand, there is a forum being provided to depositors whose deposits are not returned by companies on time. On the other, the interests of those who apply for shares in a company are also being protected by the provisions relating to the refund of the application money when shares are not allotted. It has also been made mandatory that the company will deliver share certificates and debenture certificates within a prescribed period of time. Similarly, when share transfers are refused and there is a dispute, provision is being made that pending settlement of the dispute, the transferee does not lose his rights over the dividends, right, shares, bonus, shares, etc. All these provisions are aimed at protecting the small investors and shareholders also. My friend mentioned about non-furnishing of annual reports to the shareholders. It is not that we are not concerned that information needs to be furnished to the shareholders. However, it is felt that as average shareholders may not really require all the information that is published in the annual reports today. My friend himself stated that the list of the employees drawing over a certain amount of salary can be done away with. It would be evident, therefore, that he shares the view that all the information may not be essential for an average shareholder over.